Hello and welcome to November's edition of Employment Law Live. I'm your host, Sarah Potter. So welcome to today's Employment Law Live session. Hi, David.
Hi there, Sarah. How are you?
I'm well, thank you. We are
Good.
joined today by our employment law solicitor, David Silito from Robinson Ralph. So he's your employment expert that's going to be with us for sort of the next 20 to 25 minutes, talking about all things in redundancy when it comes to a fair process. So David has 5 top tips for you today. So really excited to support you. So this is your time. So use the chat box. Someone's already said hi to us. So hello and welcome.
Facebook user.
Yeah.
Anonymous.
So
Facebook
exactly.
User.
So
You
use
did
this.
say, Sarah, we wouldn't be able to see the names. So this
Well,
could be
no,
anybody.
it's really quite annoying. But then we'll have a look afterwards when we're on there. And everyone else can see the names. It's just us, unfortunately, that can't see them. So yeah. So someone else said hi. Hopefully, it's not the same person that's just trolling us. This is probably Simon Robinson that is trolling us at the moment.
It could be playing a prank.
Brill. But if I hand over to David, then David's going to do a disclaimer. Do you want me to tell you why I work with Robinson Ralph, or do you want to do that, David? Because I'm more than happy to sing the praises for you.
You go for it, and then I'll sort of give a little introduction of myself. But yeah, it'd be great.
Okay. Fantastic. So the reason why I work with Robinson Ralph is they're not like the average employment solicitors that will make us fall asleep. So no pressure for the next 20 minutes, David.
I thought you were going to say we're below average there, but no, sorry, that wasn't where you were going.
They're not robotic in their approach, so it is very common sense, layman's terms. So as HR professionals, we're able to decipher the technology speak in law and to have it really user friendly. So if I can understand it, then anybody can. So thanks for that, guys. And humour is their value. So at the moment with COVID and everything we've been through for the past 2 years, isn't it really? If we're not laughing at Robinson Ralph's jokes from Simon, then we probably would be crying. So if you don't sign up to their weekly updates, then please do so, because they are absolutely brilliant and then the highlight of my week. So and I'm pretty good, so it's not like I've got a dull life and Simon's jokes make it good. I like to think that it is not too bad. So yeah, thanks for that then, guys. So I love working with you. I love sharing what you do. So thank you for being a part of the network and joining us today.
Thank you, Sarah. That's very kind of you to say so. And yeah, some of you watching, I suppose, may have sort of put posts up on the Facebook page as well that we've responded to. So if you have, then hello. So my name's David Silito. I am a solicitor at Robinson Ralph. I mean, as Sarah says, we try and retain a bit of humanity rather than being sort of robotic lawyers. We always strive to give sort of timely and commercial advice, and I think that sort of commercial aspect probably encompasses timely, but we do strive to be available whenever we are needed. By commercial, well, what does that mean? Well, we try and understand the goals of the business, and we give you advice so that you can make the decisions that are best for the business. And the best ever feedback that we can get is that it feels like a collaborative approach, that we are sort of part of the team and helping, particularly usually the HR department with whom we're working, implement their decisions and policies. So we won't give overcautious advice. We won't tell you can't do that. What we tell you is your options and the risks associated with each option. The talk today is going to be about redundancy, 5 top tips to avoid redundancy. Please note that this is a webinar, so you should not take this as legal advice. Don't implement any decisions, any policies based simply on this webinar. If you feel that you need advice, then you should take it from a suitably qualified employment law specialist, such as those that we have at Robinson Ralph. As Sarah says, if you've got any questions as we're going through, then do pipe up. Sarah as well, if you want to ask anything as we're going through, or just if I don't spot any questions, then please say so, because otherwise everybody will just have to listen to me for the next 20 or so minutes. So just before we get into the sort of 5 top tips, as it were, it's probably just helpful to explain and I mean, I appreciate much of what I say today will be perhaps familiar to many of you, if not all. If you don't learn anything, I apologize in advance. If you learn one thing, then hopefully you'll feel that it's been worthwhile. But before we get into the sort of 5 top tips, it's probably just helpful to recap on what a redundancy situation is and what it isn't. I mean, there are 3 sort of broad circumstances which will give rise to a redundancy situation as defined by the Employment Rights Act. They are business closure, which is a closure of the business altogether, a workplace closure, which is one of several sites or relocation to a new site, or the sort of more common situation, which is reduced requirements of the business for employees to do work of a particular kind. So broadly speaking, it's where the business doesn't have a need for employees or as many employees anymore. Where there is not a redundancy situation, there may well be a business reorganization, perhaps falling short of redundancy, that could be defined as some other substantial reason for dismissal. So that's often sort of pleaded in the alternative in defending unfair dismissal redundancy claims. If the employee disputes that there was a genuine redundancy situation, the employer can say, well, even if there wasn't a genuine redundancy situation, it was a business reorganization falling short. And that will the distinction will usually be where it's a business reorganization, maybe the functions change, but the overall number of employees doesn't change. You can have a redundancy situation where overall the number of employees doesn't change if the requirement for employees to carry out work of a particular kind has reduced or diminished. Perhaps the fact that there's no overall reduction in the numbers is attributable to a growing department elsewhere. So it'll always be very fact specific. Employers in a workplace closure situation or a business closure, well, more a workplace closure situation, I suppose, may consider relying on a mobility clause. There's no obligation to do so, but if there's a mobility clause in the contract, it may well be that the employer says, well, there isn't a redundancy situation here or here for you because we are going to exercise our mobility clause. Case law says that you can't sort of chop and change between the two. If you're going to start a redundancy process, you then can't sort of say, for example, that a role is suitable alternative employment because there's a mobility clause. You've got to rely on one or the other, really. If you are going to exercise a mobility clause, you've got to do so reasonably. So you'll have to have regard to the length of notice that you're going to give to the employee for exercising the clause and the distance travelled. And the sort of classic case from that on mobility clauses from the case law is where a bank employee was told on the Friday that he would be moving from Leeds to London as of the Monday and was required to relocate. And he said, well, absolutely no chance, and resigned and won his unfair dismissal claim. So I think as well, I mean, it's a generally accepted principle that as compared to a conduct or capability dismissal, an employment tribunal is less likely to interfere in the business decision. And I think essentially the reason for that is, one, it's not personal to the employee in a redundancy situation as opposed to the conduct and capability situation. But two, more importantly, employment tribunals aren't there to tell businesses how to run their business. And you'll often see in a redundancy situation, the employee challenging whether or not the decision was a good one. Well, an employer is perfectly entitled to make bad business decisions. And if those decisions involve making people redundant, then the fact that that may have been a bad business decision doesn't mean that the redundancy wasn't genuine. Likewise, if a genuine redundancy decision arises and somebody is dismissed, and a week later the employer realizes that they have made a bad decision, again, that wouldn't mean that there wasn't a genuine redundancy situation arising in the first place. It may mean that the employee says, hang on, there's something afoot here and a bit fishy, but on the face of it, it doesn't automatically mean that there's no redundancy situation. Bear in mind that a redundancy situation may well be examined closely by a tribunal to see whether or not there is another or unlawful reason for dismissal at play here. So, if there might be a genuine redundancy situation, but the reason for the selection of somebody might be unlawful, such as the fact that they have made a discrimination complaint in the past. So that's just something to bear in mind. And if an employee alleges that redundancy wasn't the real reason for dismissal, then it may well be at that point that actually the tribunal does want to look into and behind the business decisions, perhaps by looking at board meetings, file notes of why decisions were made and when they were made. So it is good practice to retain records of the reasons for decisions being made, and that is, of course, a bit of a lawyer's mantra. But having a paper trail can be absolutely vital, and tribunals love nothing more than a contemporaneous written record. It makes their life much easier because it is far more reliable than somebody turning up many months down the line and saying, yeah, this is what we did for these reasons.
Yeah. So with that business case, how robust and thorough, and what does it need to sort of have in it?
Well, I think that it needs to demonstrate that the decision is genuine. So from an employment law perspective, it doesn't need to, it's not going to be assessed like a sort of a master's degree level business analysis or whatever. I've never done a business master's, so that may be apparent from what I just said, but it's not that sort of assessment. It's just something to demonstrate that the decision was genuinely, legitimately made, and it may be important when it was made. Brilliant. As well.
Yeah. So if there's any record of like it went to this committee or this meeting at this date, and here's the minute notes of it as well.
Yeah, and it can it can happen that somebody says, well, there's a fear that somebody might allege that they were dismissed because they raised an allegation of sexual discrimination, perhaps. Yeah. Well, a company that can show that the decision was made and that the ball was rolling before that allegation was made will be in a much better position to defend that claim.
Brilliant.
Okay. So top tips.
All 5 of them as well. I'm really excited.
I know. How are we going to string it out to 5? It's,
I thought you'd have loads more. You've got loads more.
Yeah. Well, I mean, I'm going to go broadly through, I think, the sort of process that a tribunal will follow, and we'll look at the issues that a tribunal will address in deciding whether or not the dismissal was fair. So it's always helpful to explore alternative measures to redundancy. That will help demonstrate that you're a reasonable employer, that you've taken all reasonable steps to avoid the redundancy of the employees who are ultimately perhaps made redundant. So that might be offering voluntary redundancy. Usually that will be an enhanced payment in return for the employee signing a settlement agreement whereby they agree not to bring any claims against the employer, but it may well be that there's a policy implemented at the employer that simply says, well, we will do that, and if you take voluntary redundancy, you'll get X sum, perhaps your weekly pay not capped at statutory rate, or a month's pay per year of employment. Is there an option to change working hours? Obviously, that would be with the agreements of staff, but that agreement may be much easier to obtain where they know that the alternative is redundancy. Moving employees into other roles as well, and that's something that we'll come on to specifically once you've started the process as well. But even before you've started that process, is there a reorganisation that you can do, which again people might agree to, where they know that the alternative is potential redundancy? Have you got temporary or contract workers who you might be able to let go? Can you place a freeze on recruitment as well, and limiting or stopping overtime to control costs, and certainly having people working overtime in a department that is at risk of redundancy is likely to be a bit of a paradox. So it won't be viable. Those alternatives won't be viable all the time, but it's important to consider them, and again make a record that you have considered them, because that will be useful at a later stage. If you haven't made a record, it doesn't mean you can't give evidence that they were considered, assuming that evidence is true. But yeah, a written record, as I say, is always helpful. So secondly, have a look at whether or not there's a policy that your organisation has. Is that a contractual policy or otherwise? How prescriptive is it? But something that I always say is that if you've got a policy, you will be held to the standards you've set in that policy. That policy may even have set selection criteria that should be applied, but it may be more flexible to suit the particular circumstances, or it may allow you to be more flexible to suit the particular circumstances. But have a look at the policy. If you haven't got a policy, fine, no problem. Do have a look at the Acas guidance on redundancies, because that will be helpful. In terms of the procedure to be followed, well, you may well have come across the band of reasonable responses test that tribunals apply when deciding whether or not dismissal was reasonable, perhaps in a gross misconduct situation. Well, that range of reasonable responses test applies in redundancy, it applies to the decision, and it also applies to the procedure. And what that means is that there is an element of leeway, an element of discretion that an employer has in following that process. What it does mean is that you've got to be reasonable at every stage. That's what the tribunal will look at. But the appeal tribunal has been keen to emphasise in redundancy and in many other cases that it's not for the tribunal to impose their own standards on those of the employer. They can't substitute their own decisions, their own judgment for the employers. They've got to consider whether or not the decisions that were made were within the range of reasonable responses. We'll look at some of these points in more detail later, but in summary, you've got to warn and consult with employees, adopt a fair basis on which to select for redundancy, and consider suitable alternative employment. Those are the three sort of key points. Do you need to offer a right of appeal? Well, the short answer is no, you don't need to. The Acas guidance on handling small-scale redundancy suggests that it would be good practice to offer an employee a right of appeal, and I would agree with that. The Acas guidance says that this can enable disputes to be resolved internally without recourse to employment tribunals. And that's one good reason for allowing an appeal. It will allow any concerns that the employee has about the process to be resolved, and it may well be that once you've explained why something has happened to the employee, they're satisfied with that. If there is any unfairness in the process, and that unfairness is something that the employee wishes to challenge, then the appeal process will allow you an opportunity to remedy that unfairness. And if there was originally unfairness remedied on appeal, the dismissal will not be unfair. Conversely, you can obviously mess it up at appeal stage, and that might lead to lead to unfairness, but it may well be that compensation is limited at that stage because the employee has already been dismissed. So the benefits probably outweigh the risks in terms of holding an appeal. The Acas Code of Practice on Conduct and Grievance, and disciplinary and grievance matters doesn't apply to dismissals by reason of redundancy. It doesn't need to be followed, and also following on from that, if it's not followed, there's no prospect that the tribunal will uplift or reduce compensation because either the employer hasn't perhaps allowed an appeal or the employee hasn't appealed or raised a grievance. Excuse me. 3 is consider the consultation obligations. So, I mean, generally speaking, I'm sure you'll all appreciate this, but redundancy can cause a great amount of anxiety for employees. So just letting people know what's going on will be hugely beneficial. Having a plan in place, that plan being transparent and providing support for employees where possible is vital. If you're required to involve the unions, obviously you'll need to do that from the outset and make sure that you're not bypassing them. In terms of the consultation, there are no set rules for any situation where there are fewer than 20 redundancies proposed. Ordinarily, there will be at least 2 meetings, an initial consultation meeting, and then a final consultation stroke dismissal meeting. But where there are 20 or more redundancies proposed at one establishment within a 90-day period, and it will not surprise you, the lawyers have argued about every element of that, what proposed means, what within a 90-day period means, and what at one establishment means, and what one establishment means is different in the UK to elsewhere in Europe. But yeah, more than 20 employees at one establishment within a 90-day period, there is an obligation to collectively consult. What that means is that, firstly, the dismissals, the redundancies can't take effect for a minimum period. So where that's between 20 and 99 employees, consultation must begin at least 30 days before the first dismissal takes effect. Where that's 100 or more employees, then consultation must begin at least 45 days before the first dismissal takes effect. Collective consultation doesn't have to last that long. That's a sort of common misunderstanding. So it doesn't need to last that long. It is just the case that once you've started it, the dismissal can't take effect for the prescribed period. You can serve notice. It's just that the employment can't terminate for that 30 or 45 days. So it's essentially a moratorium on the dismissals.
Yeah. Just on those consultations, David, is there a situation if the business is less than 2 years old? Is there any loopholes with length of time of trading? No. There's a distinction with TUPE for consultation for a micro business, which is 10 employees or less. But no, there's no escape based on the age of the business from the so it is just employee numbers.
Yeah. So the 2 years. Obviously, if your business is less than 2 years old, you're unlikely to have any employees with more than 2 years service, but the collective consultation obligations are completely separate from any unfair dismissal claim, if that's the angle that you were thinking of. Facebook user, whoever you are.
It's Lee. So thank you, Lee, for your question.
Brilliant. Thanks, Lee. So it's not so it doesn't give rise to an unfair dismissal claim. Although it might be relevant to an unfair dismissal claim in terms of failing to consult, but it's essentially different. What it will give rise to, where the employer falls down, is a protective award of up to 90 days gross pay, and that's not subject to any statutory caps. So that's actual pay. Okay. There's a special circumstances defence, which is to be interpreted very narrowly, and even a even an administration of the business won't necessarily mean that that the special circumstances defence applies or succeeds, and even where there are special circumstances, then the employer still got to take all such steps towards towards compliance as are reasonably practicable. Okay, so 4 is have in place objective selection criteria. So have a fair pool. Well, there are no fixed rules about how the pool should be defined. It's primarily a matter for the employer to determine, but there are, of course, limits to that. It can be attractive commercially to have a narrow pool because you reduce the number of employees affected by the process, but obviously you then run the risk of challenges from the employees affected. The importance, one of the key benefits of consultation for the employer is that it allows them to deal with concerns. It's very difficult, in my opinion, for an employee to subsequently raise an employment tribunal a point of unfairness that they haven't raised with an employer through the consultation process. Because one, well, if they didn't think of it at the time, why should the employer? And two, well, there was no opportunity for the employer to remedy that at that stage, and that's the whole point of consultation. When dealing with selection criteria, well, yes, they've got to be objective. There can be an element of subjectivity because, of course, nothing is wholly objective. It's just got to be reasonably objective. So you can increase objectivity to what may be essentially subjective judgments by having a number of people whose scores are then averaged. But again, those scores were going to be subject to consultation as well. The tribunal will not ultimately rescore employees. Their analysis will be confined, their assessment will be confined to whether or not the employer has conducted the scoring process reasonably. If, as an employer, you are going from one situation, going from some roles to people being engaged in another role, so you're effectively undertaking a recruitment exercise for a forward-looking recruitment exercise for a new role rather than selecting 5 welders from 10, then then you will have greater leeway and you are able to conduct a more subjective process. Bear in mind that if you've got any women on maternity leave who are pregnant, they will have the if they are selected for redundancy, they will have priority if there's any suitable alternative employment. And that's the 5th tip, which is always consider whether or not there is suitable alternative employment. As I say, do bear in mind if you've got the women on maternity leave or who are pregnant, there is that additional obligation in the maternity and parental leave regulations. Whether or not the role is suitable is to be determined essentially by the employee. So certainly if we're talking about a decision by the employer not to pay them redundancy pay because a suitable alternative role offer has not been accepted. One really important point I think is that to remember is that if you've got suitable alternative roles and you've got doubts over whether or not one of the potentially redundant employees is suitable, is going to be able to do it, there's a statutory trial period for that that will last 4 weeks. It can be extended before the start of the trial period, but it can be unfair. It can be an unfair dismissal where no trial period was considered or offered where there was suitable alternative employment available. So do think really carefully if your decision is that we can say this person isn't suitable for the role even without a trial period. And that's me.
Brilliant. Oh, thank you very much, David. Yeah, brilliant. I think we're all sort of geared up and ready then. So should we get any more redundancies? Yeah. How do you sort of see with the end of obviously furlough and things like that? Do you think we're going to get an increased demand in companies pivoting and resizing and restructuring? What are you seeing in the market?
Possibly. Well, I mean, what I'm seeing mainly is employers focused on moving from to a more permanent home or hybrid working arrangement. So obviously that affects office space, but doesn't affect overall employee numbers. So yes, furlough has ended. I haven't sort of seen or heard anecdotally about any massive spike in redundancies, but I think we're probably not through the woods yet, are we? With the economy, and there are various other factors than just COVID that are obviously impacting on the economy right now. So yeah, I mean, it's always an issue. It's always a concern. A lot of companies will take the view that we'll go enter into a settlement agreement because it's not worth the hassle. But yeah, certainly not all. So I think we could see an increase in redundancies over the coming months, but who knows? Who knows
exactly? And who would have thought that this would be the way of the world as well at the moment? So yeah, always good to have you. Yeah. Brilliant. Well, if we haven't got any final questions coming through for David, we'll end the session there. And David and his colleagues from Robinson Ralph will be joining us. It's every month, so it'll be the last one of the year already.
Terrifying.
I know, Christmas already. So I want to see you.
We're already halfway through Strictly.
So the next one will be Thursday, the 2nd of December, and we hold it at 12 o'clock. So it's in your sort of lunch break as well. So make sure you take that time out. But again, we're here to help you. So if you've got any burning questions, topics that you want us to cover, then get in touch with either of us. I'll send the recording round as well, and this will be available under announcements on the Facebook page, so you can watch the replay back. And we look forward to seeing you next time. So thank you very much for joining us today, and we'll see you soon. Thanks, Joe, for your feedback. And we'll see you next time. Take care.
Thanks, everybody.
Bye, everyone. Thank you, David. Bye. Bye.